Learning the language of law is similar in some ways to learning a new language. Whether the words are familiar or unfamiliar, you'll need to use legal terminology quite precisely. Otherwise, you will leave your words open to misinterpretation. We live under what's called an adversarial legal system. The adversarial legal system is a system of justice where opposing parties battle against each other in court trying to get a result that favors them. The judge makes sure each side is treated fairly. There is always a winning and a losing side in such a system. In our adversarial legal system, opponents and critics are quick to seize on any perceived inaccuracies in the language used in a written oral exchange. The extent of the inaccuracies can have a devastating effect on the outcome of a case. The crucial paragraph or provision in a contract, for example, may be deemed void. A court may decide against your firm's client because certain documents didn't clearly request the type of relief desired. An appeal may be lost, forcing the client to pay the other party's attorney fees and costs. Attorneys or paralegals may be subjected to disciplinary actions or lawsuits. Consider the six-letter word allege. In common usage, the term is used often to simply make a claim, as in the following examples. Agnes alleged that her boyfriend had a date with someone else. Mr. Andrews alleged that I misused my computer email privileges. The police alleged that the suspect stole all 7 goldfish. As a legal term, however, the word allege is used to describe the action of formally stating a specific charge in a court of law or legal document. The related legal term allegation refers to the specific charge against a person made in accordance with state or federal legal codes. Each specific charge may alternatively be referred to as a cause of action. At first glance, the distinction between the ordinary and legal usage may not seem entirely clear. The differences lie in the available proof of the described conduct. Media and lay people use the term allege to describe suspected actions without necessarily obtaining proof to back up the claim. By contrast, legal professionals are usually limited to alleging only what they can prove. Various rules governing the practice of law make it quite clear that attorneys will likely face disciplinary action for making allegations which are either untrue or lacking reasonable grounds for belief. Disciplinary action may include suspending or revoking a lawyer's license under the bar to practice or even a lawsuit against the attorney. Another word frequently misused in the media is the word innocent. At one time or another, you've probably heard or read something similar to this statement. John Doe pleaded innocent to the charge of murder today. Our legal system presumes that every person is innocent until proven guilty, beyond a reasonable doubt. However, there is no legal plea of innocent. In virtually every state, the available pleas to answer a criminal accusation under statute law is one of the following. Guilty, an admission of having committed the crime alleged. Not guilty, a denial of having committed the crime alleged. Not guilty by reason of insanity, a denial based on an inability to appreciate the criminality of an act or to form criminal intent. Double jeopardy or formal jeopardy, a statute that forbids charging someone with a crime for which he or she has already been found not guilty. Of course, those who refer to common law can always simply object to the entire proceeding and demand to be tried by peers under the common law. Then, of course, they have the plea called no contest, often rendered in Latin nolo contendere, essentially the same as a guilty plea in a criminal case, except that it can't be used as evidence against a defendant later in a private or civil lawsuit. A person found not guilty is said to be acquitted. Formal legal release from charges and from any legal or financial consequences arising from the charge is called an acquittal. Let us look now at common English terms. When used in a legal context, many common English words and phrases take on a different shade of meaning than in their ordinary usage. The word injury, for example, ordinarily refers to sort of physical harm done to the body. In legal usage, however, injury has a broader meaning of an invasion of legal rights that adversely affect a person's body, property, or reputation. Loss, harm, or hurt that results from an injury is known in legal terms as damage. An act or failure to act that infringes on the rights of another and causes damage to that individual is known as a wrongful act. Exceptions are often made when a person inflicts damage in the exercise of an equal or superior right, as in a case of self-defense against an attacker. A party that considers itself injured may legally seek what's called relief, which in legal terms is understood as financial compensation for loss sustained by the injury, or certain types of compulsory conduct such as payment of alimony or child support, or prohibition against certain types of conduct such as dumping toxic waste. Relief in the form of compulsory or prohibited conduct is known as equitable relief. The legal means by which a person's rights is enforced and relief is gained is known as a remedy. A remedy consisting of financial relief is commonly referred to as damages, which the court awards to the injured party. Damages may be further characterized as actual or punitive. Actual damages, also known as compensatory damages, represent a sum awarded to the injured party as financial compensation for loss or damage. Compensatory damages may include financial compensation for expenses, lost work time, and expenses incurred as a result of the injury, such as medical bills and the like. Compensatory damages may also be awarded for mental anguish or physical pain arising from the injury, known as pain and suffering. Punitive damages, awarded beyond compensatory damages, are an additional award intended to punish the defendants for malicious or outrageous conduct. By contrast, a remedy that involves equitable relief is commonly known as an injunction, which is a command issued by the court either forbidding or compelling specifically defined activities. A command issued by a court is known as an order, and is often delivered formally in a document known either as a court order or simply an order. State and federal codes, or statutes, which set out in detail the laws enacted by a state or federal legislature, often provide statutory definitions of legal words and phrases. The term statutory here implies that the definition has been officially authorized by a statute. That's why it's called statutory law, which is a law enacted by the state or federal legislature. Statutory definitions are commonly found near the very beginning of the state or federal code. One must bear in mind, however, that courts are rarely bound to statutory definitions. In fact, as part of our system of checks and balances, courts are specifically empowered to interpret legal words and phrases. Of course, this is only in chancellery courts, which are really more advisory courts. But under those auspices, court justices often exercise this power through critical analysis of the multiple definitions of words found in various dictionaries, as well as through the careful study of statutes and rulings of other courts, both past and present. Many appellate courts have published decisions that for page after page analyze, evaluate, define, and finally decide the meaning of only one or two words. Just a few examples of such terms include these. knowingly, which may be defined generally as acting with awareness of consequences, or more specifically with deliberate intent to harm or to disobey the law. Sudden and accidental, a phrase found vague and ambiguous in more than 50 cases and clear and unambiguous in more than 50 others. Explosion, the specific definition of which may or may not provide insurance coverage. Day, which has been defined a number of ways, including a 24-hour period, the period including within daylight hours, and the period during which work is performed. Extend, which is often analyzed with reference to type of behavior or conduct covered by a legal order. Combination, which has been defined in a variety of ways, including the joining of two parts and the coming together of more than two parts. Since legal definitions vary so widely, a court's decision about the meaning of a word or phrase may depend entirely upon how well one has researched and constructed documents. It is therefore crucial to develop a comprehensive knowledge of legal terminology and to become familiar with the context of prior accepted usage, normally called precedents. Latin, which comes from the Roman ancient days, has become the esoteric language of the legal system, so as to esoterize and keep the secret within the Bar Association and only those licensed by the bar to practice law. Of course, this does not limit the common people to practice their own legal representations by simply providing themselves as sui judices, but even then, they must understand a bit about the Latin and the law. Progressive legal scholars and writers often prefer plain English and simplicity so that their entire audience will understand them. However, some Latin phrases can be used to sum up the comments of judges, lawyers, and scholars in just a few words rather than through lengthy explanations. The use of the Latin is a succinct way of expressing certain opinions without the uncertainties of English usage rather discussed earlier. But in reality, as I've said, this has become a term of art. That is, it is an esoteric terminology limited to the elite practitioners of bar law. Though decisions regarding the use of Latin words and phrases may sometimes be left to many supervising attorneys, the statutes require the Latin to be used because, as we said, the system is esoteric and therefore is designed for such usage. Because Latin forms the roots of thousands of English words, learning the phrases commonly used in the legal profession isn't as difficult as it sounds. Let us look at some of these constructions. Common Latin legal terms. Ab absurdo literally means from the absurd, often used to describe an argument that seeks to establish its validity by pointing out the absurdity of the opposing argument. Ad initio, from the beginning. Ad infinitum, without limit, forever, to infinity, endlessly. Certiorari, which literally means to be certain or assured, used to describe petitions from a higher court to certify the record of a case tried in a lower court, so that the higher court may review the case. Contra, which means in opposition to, against. Damnum qui injuria, no basis for a lawsuit, loss without injury in the legal sense. Dixi, I have spoken, the matter is settled. In flagrante delicto, which means while the wrong is blazing. Then you have lex talionis, an eye for an eye, a tooth for a tooth. The list represents only a very small fraction of Latin terms that will be used in law. For such purposes, one must look into more extensive dictionaries to understand the words of Latin. We'll move on sin mora, that is, without delay, to other topics. Let us look now at litigation. Many attorneys and paralegals work for law firms that are occupied primarily with litigation, a general term used to represent a variety of different kinds of legal actions. The term action here refers to the use of the court system to enforce or protect laws or legal rights. An action is sometimes referred to as a proceeding. Actions can be broken down into two basic types or categories: criminal action and civil action. A criminal action is initiated when a crime and offense committed against society as a whole has occurred. Crimes include such wrongful activities as theft, murder, treason, rape, kidnapping, etc. The body of laws that distinguishes society-wide rights, responsibilities, and liabilities is commonly referred to as criminal law. A civil action, by contrast, is initiated when two or more private parties, which may include people, organizations, or institutions, become involved in some sort of dispute involving private rights or responsibilities that can't be settled by themselves. These are usually taken up in all categories which are defined as fictitious corporations or fictitious names or entities. In such cases, the court functions as a third party to settle the dispute between them. Though it can refer to legal actions in general, the term litigation is more frequently and specifically used to describe civil actions. The language of civil action. Litigation is a broad field that includes a variety of subcategories. Let us look at some of these. Violation of personal rights commonly are referred to as personal injury. Then you have business disputes, you have contract disputes, you have real estate disputes, you have family law disputes, and you have disagreement over inheritance issues, also known as probate law. A few general terms apply to almost all fields of litigation. For example, the party that initiates an action by making a formal complaint in court is referred to as a plaintiff, while the party that must defend its actions is called the defendant. Several defendants named together in the same suit are typically referred to as co-defendants. Similarly, several plaintiffs initiating an action together are referred to as co-plaintiffs. An action initiated by one or more plaintiffs on behalf of a large number of people who have suffered similar injuries is commonly known as a class action suit. The lawyer who represents the defendant is known as a defense attorney. The lawyer who represents the plaintiff is one referred to as a plaintiff's counsel. Exceptions are made in the areas of family law, which governs divorce and child custody, guardianships, dealing with issues of child supervision, and probate. In such actions, the party initiating the action is typically referred to as the petitioner, and the representing attorney is referred to as petitioner's counsel. In criminal proceedings, the plaintiff is called the prosecution, and usually considered to be acting on behalf of the people of the United States or the state where the crime occurred. Lawyers on opposite sides of a lawsuit are often referred to as opponents or opposing counsel. Opposing attorneys may request a court to determine the legal issues in a formal proceeding known as a trial. A type of relief sought in an action depends on the action at hand. An action at law usually involves some sort of financial compensation for loss, damage, or injury. An action at equity, by contrast, usually seeks some sort of equitable relief. In some states, actions at equity are still determined by a special court known as a court of equity. In most states, however, actions at equity and actions at law are determined by a court of law, which is a statute court. The body of laws that define private rights and responsibilities is known as civil law. The rules for conducting civil election are known as rules of civil procedure. Civil actions brought in federal courts are governed by federal rules of civil procedure, while those initiated in state or local courts are governed by state rules of civil procedure. Federal and state regulations determine the maximum amount of time that may pass between an injury or offense and initiation of an action, known as the statute of limitations. The maximum interval varies according to the type of injury or offense committed. Of course, this is not so in common law. In common law, there is no statute of limitations. There is no time of limitation. Let us look now at jurisdiction. The first task facing counsel for a plaintiff or petitioner is to select the court in which to bring the action at hand. In choosing a court, the attorney must determine which court has the authority to hear a particular case. Such authority is commonly referred to as jurisdiction and is granted to the court by either federal or state government. Courts can exercise several different kinds of jurisdiction. A court empowered to hear a lawsuit, when it first goes to trial, is said to have original jurisdiction. Courts authorized to hear cases in which a verdict is appealed are said to have appellate jurisdiction. A court that has the sole authority to hear a particular case is said to have exclusive jurisdiction. By contrast, two or more courts authorized to hear a particular case are said to possess concurrent jurisdiction. The principle of concurrent jurisdiction is one means of ensuring a fair trial. A trial is the process of deciding a dispute between two parties in court before a judge or jury. For example, if a case has received a lot of publicity, a court sharing concurrent jurisdiction with other courts may decide that justice would be better served by holding the trial in a different county or judicial district. In such cases, attorneys seeking a fair trial for their clients may sometimes petition the court, called a move, for a change of venue. A venue is the place where a trial is held. The term refers specifically to the geographic area where an action is to be tried. Questions of jurisdiction involve the authority of a particular court to hear a certain case. Jurisdiction is often determined by the type of action being brought before the court. Civil actions can be broken down into several categories. A lawsuit directed against property, such as an action to retrieve goods or a title to real estate that hasn't been fully paid for, is known as an in rem action. The term is derived from the Latin words res, which means thing. A court has jurisdiction in rem, or that is in the matter, only if the property in question is located in the same state and often the same county as the court. If the property in question is located in one state and the defendant lives in another, a plaintiff can initiate a quasi-in rem action. In such cases, the court where the property is located has jurisdiction over the property only. The most a defendant stands to lose in a quasi-in rem action is his or her share of the value of the property. A lawsuit against a person is referred to as an in personam action and can be initiated only in a court that has jurisdiction in personam, or jurisdiction over the person, sometimes also called in personam jurisdiction. Usually, jurisdiction in personam is granted to courts located in the same state or county where the defendant lives. A state court may also obtain in personam jurisdiction over anyone if process is served while that person is staying or traveling within the boundaries of the state. Long-arm statutes sometimes allow one state court to obtain in personam jurisdiction over a person in another state if that person does a significant amount of business in the state in which the court is located. The doctrine of lis pendens holds that a pending in rem action is legally considered public notice of a legal dispute. Anyone interested in purchasing disputed property will be bound to the court's decision in all matters concerning the property. Initial procedures. A formal legal document constructed according to rules of court and procedure is called a pleading. Most pleadings begin with a specifically constructed heading, known as a caption. A caption includes pertinent information such as the names of all plaintiffs and defendants, the jurisdiction and venue of the court, and the type of document which is being submitted. In order to initiate a lawsuit, the attorney for the plaintiff must submit to the court a special type of pleading known as a complaint. The complaint names the defendant and clearly states the allegations against the defendant. The portion of a complaint in which the plaintiff specifies a demand for damages and the amount of the claim is known as an addendum clause. In certain actions, divorce for example, the complaint is referred to as a petition. In divorce law, a case is begun by filing a petition. A complaint that includes specific facts together with a sworn statement affirming under oath the truth of the facts is known as a verified complaint. The plaintiff must be able to prove every factual allegation contained in a verified complaint. Otherwise, important parts of the complaint may be stricken as false or misleading, and the plaintiff's credibility may suffer. A sworn statement is commonly known as an affidavit, and the person making the statement may be referred to as the affiant. In the case of a verified complaint, however, the sworn statement may be known more specifically as a verification. The affiant's signature is usually witnessed by a notary public or some sort of seal, who then confirms his or her identity and authority by signing a statement known as an acknowledgement. Note that in certain cases, an affidavit or verification can be submitted to the court. Such situations arise, for example, when a party's religious beliefs prohibit making sworn statements. At such times, an unsworn formal statement called an affirmation is submitted instead of an affidavit. To strike a part of a complaint or other document means to remove it from the official record. Formally initiating a lawsuit by filing the appropriate pleadings is known as bringing suit. As a result, the court issues a legal order or process compelling the defendant to appear in court. In its legal sense, the term appear may refer to physically making an appearance or formally submitting a pleading. Plaintiff's counsel may deliver the complaint by hand delivering it or sending it via either registered or certified mail to the court. Usually it is better to send it registered because it also brings the postal service under oath. The complaint is listed in a record of cases filed in the court, commonly referred to as a calendar or docket. It's assigned a docket number by the clerk of the court. A docket number represents the lawsuit's place in the order of cases before the court and is listed in the caption of all future documents relating to the suit. The clerk of the court is an administrative official who is there to keep the court's records, accepts the fees associated with various court procedures, such as filing and certifying legal documents. He may not interpret, he may not comment on any of the documents being presented. He is there simply to do what the law requires him to do as the clerk of the court. Fees and costs. The terminology relating to various costs incurred during a trial can be somewhat confusing. For example, the fees for filing and other services provided by the clerk of the court are commonly referred to as court fees. The terms court costs, on the other hand, refers to all the costs involved in litigation, including court fees, witness fees, and the cost of making a transcript of the witness testimony. Court costs, however, don't include attorney fees, which are the fees charged for all services rendered by lawyers involved in the case. After the complaint has been filed, the defendant must be formally notified and compelled to respond by a method known as process. Service of process is the delivering of summonses or other legal documents to the people who are required to receive them. The defendant is notified of the lawsuit through a formal document known as a summons. Accompanied by a copy of the complaint, a summons typically requires the defendant to file a response within a specified time frame or else lose the case by default. The person responsible for delivering the summons is known as a process server. The summons and complaint may be delivered according to the following methods: personal delivery by hand, known as personal service; leaving the summons and complaint at the defendant's last known address, known as constructive service; mailing the documents, delivering them to defendant's representative, or publishing them in a newspaper known as substituted service. That is, the summons is used to notify the defendant of the lawsuit. Defensive responses. After receiving a formal complaint, the defendant or defendant's counsel may file a pleading in response. One type of response is known as a demurrer, an objection to the suit based on specific legal errors contained in the pleading. It is, in fact, a legal disagreement. Of course, it is not necessarily a denial of the facts. For example, a demurrer may allege that a complaint fails to state certain facts that legally constitute a cause of action, or that the court lacks jurisdiction. One of the greatest elements at the disposal of any defensive response is to challenge jurisdiction and then to file an independent complaint. But never must the defendant allow himself to be in the position of a defendant. He must be the plaintiff. The litigant's attorneys may argue the matter before the judge at a determined date. After hearing the arguments, the judge may either support, sustain the demurrer, or deny, overrule it. The federal courts and other jurisdictions, a demurrer is known as a motion to dismiss for failure to state a cause of action, also known as motion for judgment on the pleadings. If a demurrer isn't filed or overruled, the defendant's attorney must reply to the charges in the complaint within a set number of days. The formal document used to reply to a complaint is known as an answer. An answer typically consists of a general or specific denial of the allegations point for point set forth in the complaint. If the complaint isn't verified, the defendant may file an answer in which the allegations are generally denied. The defendant does not need to file an affidavit and isn't legally bound to his or her denial later on. A defendant served with a verified complaint, that is, a complaint with point-for-point arguments, must usually file a verified answer, point-for-point rebuttal, a document specifically admitting or denying each allegation in the verified complaint under oath. Failure to file a verified answer inclines the court to accept the plaintiff's statement that all the facts verified in the complaint are true. Failure to deny a specific allegation inclines the court to accept the allegation as true. A defendant's answer may admit the allegations in the complaint, but also state one or more reasons that prevent the plaintiff from winning the suit or advancing further. Such reasons are commonly known as affirmative defenses, and typically consist of assertions of fact and law that attack the plaintiff's right to bring the lawsuit. Some of the affirmative defenses commonly alleged in an answer include the following: accord and satisfaction, an agreement between parties that a specific action on the part of the defendant will resolve the dispute. For example, a debtor owes a creditor $10,000. The debtor offers the creditor $9,000 to pay off the debt in full, and the creditor accepts. Then you have assumption of risk. a legal principle that the plaintiff possess sufficient knowledge or information of the dangers involved in, for example, a sporting or recreational activity to assume legal responsibility for any injuries or losses. Someone who goes skydiving, for example, can be said to know the risk of crashing in the ground at high speed. Then you have contributory negligence, which is an assertion that the plaintiff's own conduct contributed to the cause of the loss or injury. And the most famous of all is the estoppel, a prohibition forbidding the plaintiff from denying past statements or activities upon which the defendant may have based his or her own actions. For example, Jason tells Susan that it's okay to fish on his land. Susan does so. Jason sues her for trespass because Jason told Susan that it was okay to enter his property. Jason is stopped from suing Susan. Then you have laches, a doctrine asserting that the plaintiff's delay or failure to assert a right may allow the court to deny relief. For example, Bob and Jane entered into a contract to sell a piece of land. Jane refuses to sell the land to Bob as agreed. 9 years later, Bob sues Jane for the land, which has increased greatly in value. Both would be barred from recovery due to laches. In other words, he waited too long to sue. It is essential that the defendant allege all affirmative defenses related to each cause of action set forth in the complaint. In fact, as we have said, there are many procedures he can do. But the most important point in all this is that he take the position of a plaintiff, him or herself, never to be in the position of a defendant. If an affirmative defense is omitted and not added in a timely manner, the defendant loses the right to use it. In addition to an answer, a defendant's lawyer may also file the following types of pleadings. The counterclaim, a claim the defendant makes against the plaintiff, to which the plaintiff must answer with a formal pleading known as a reply. Then you have the cross-claim, a counterclaim filed against a co-plaintiff or a co-defendant. And then you have cross-action, an action brought against the plaintiff arising from an allegation the plaintiff made in the original complaint. In the state of California, a pleading known as cross-complaint is filed in place of a counterclaim or cross-claim. Let us now look at motions. Attorneys often submit pleadings aimed at convincing the court to rule, that is, make a decision in favor of their client. Special pleadings seeking a favorable rule are commonly referred to as motions. An attorney who submits a motion is said to move for a ruling of a certain kind. A motion to dismiss, for example, is a formal request that the plaintiff's suit be dismissed or dropped without further consideration. Termination of a case without trial is known as dismissal. Common reasons for filing a motion to dismiss include the following: absence of in rem, quasi in rem, in personam jurisdiction, inappropriate venue, defectively composed summons, referred to as insufficiency of process, inappropriately served summons, referred to as insufficiency of service of process, failure to set forth a claim for which relief may be legally granted, failure to name or join a necessary part, mistaking the name of a party in the suit. It is important to know that any type of creditor letters, any type of documentation sent to one's home or address or P.O. box can also be turned away legally by stating the failure to set forth a claim for which legal relief may be granted. Other motions include motion for a more definite statement, typically filed when a complaint or other pleading is so general or ambiguous that the other party cannot properly respond. Motion to strike, filed by either side in order to have an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter stricken from a particular pleading. Motion for judgment on the pleadings, filed by either side after both the complaint and the answer have been filed, requesting the court to judge the merit and legal soundness of the pleadings. Motion for summary judgment, a request for judgment in favor of the defendant when the defendant does not deny the facts set forth in the complaint, but does deny that the facts legally constitute a cause of action. An attorney submitting a motion may be required to support the motion through oral judgment, that is, a verbal presentation of the related facts and legal issues. A civil trial can be a long and costly undertaking. Judges and attorneys frequently seek means of resolving civil disputes outside the courts, generally referred to as alternative dispute resolutions. These options include the following: mediation, arbitration, mini-trials, summary jury trial, out-of-court settlement, confession of judgment. Let us look at these quickly. Mediation is an informal process in which a neutral third party tries to persuade the parties to settle their differences through compromise. The third party is often referred to as a mediator. Mediation may also be referred to as conciliation, in which case the neutral third party is called a conciliator. Arbitration is a more formal approach. A neutral third party, known as an arbiter, listens to both sides and decides on the most fair and productive way to settle the dispute. Arbitration may be binding, in which case the parties have agreed in advance to abide by the arbiter's decision. Or arbitration can be non-binding and merely advisory, in which case the arbiter's decision serves merely as a recommendation. Increasingly, adversaries in civil dispute are choosing to resolve their differences through informal trials, commonly referred to as mini-trials. Such trials are typically organized and directed by private organizations. Retired judges and lawyers are typically engaged to hear the judgments, and all parties in the dispute agree to abide by the final decision. A federal court may seek to resolve a potentially lengthy jury trial by ordering a summary jury trial, an abbreviated presentation before a jury of only a few people. Attorneys for both sides present their claims together with evidence ruled admissible by the court. Afterwards, jurors submit a non-binding verdict. The attorneys may interview the jurors to determine their thoughts about the issues. Alternatively, both parties may arrive at the formal agreement known as a settlement. While opponents can enter into such an agreement at any point during the trial, they may arrive at an out-of-court settlement before the case reaches trial. Lawsuits involving debt, meanwhile, may be settled without trial if the debtor enters into a formal admission of debt. Such an admission is known as a confession of judgment and serves as a ruling in favor of the plaintiff. Certain cases, such as a trial in small claims or magistrate court, may be determined through a simplified type of trial known as summary proceeding. A summary proceeding may be determined without the usual requirements of a trial, such as a jury, complaint, or discovery. The remedy or means by which a legal right is enforced and relief is obtained reached in a summary proceeding is known as summary remedy. Let us look now at discovery. Attorneys often file documents confirming their agreement on various matters relating to a particular case. Such formal agreements are known as stipulations. Attorneys may file stipulations agreeing on a number of points, such as extending the time for pleading or admitting or omitting certain facts. Among the most common stipulations filed are documents relating to the investigation and determination of facts related to the case, a process known as discovery. Obtaining information about the case and exposing the essential issues before going to trial saves a great deal of time and effort. A number of procedures have been established by federal and state rules, known as methods of discovery. Such procedure must conform to specific guidelines and are usually set in motion through the submission of one or more stipulations. The common documents and procedures are outlined in the following statements. You have first of all the bill of particulars. Certain states do not require a complaint to set forth the details of the amount due on a contract for the sale of goods. Instead, the plaintiff is required to state only the total amount owed. In such cases, the defendant may file a document requesting details concerning the amount owed, known as a demand for a bill of particulars. In response, the plaintiff must deliver a written statement, known as a bill of particulars, which is an itemization of the amount owed. For example, a grocery store is suing to recover money for items that a shoplifter did not pay for. The plaintiff must file a bill of particulars listing what the defendant took and the price of each item. Then we have interrogatories. Once an action has been initiated, any of the litigants may submit a list of written questions to any of the other litigants involved in the suit. These written questions are referred to as interrogatories. Plaintiffs may serve interrogatories either together with the summons and complaints or at a later date. Defendants may serve interrogatories at any point after the action has been initiated. Interrogatories must be answered in writing and signed by the answering party under penalty of perjury. Each question must be answered separately and completely. If the answering party objects to any of the questions, reasons for the objections must be fully and clearly stated. Then you have a deposition. Before a trial begins, attorneys will often ask a witness for testimony that is given under oath, but not in court. Both the process of gathering the testimony and the testimony itself are referred to as a deposition. The attorney conducting the interview under oath is said to depose the witness. The witness is commonly referred to as a deponent. A deposition on oral examination takes place in the presence of attorneys for both sides and is recorded by a court reporter. Two kinds of depositions are commonly conducted: depositions on oral examination and depositions on written questions. In a deposition on oral examination, attorneys for both sides ask the witness questions. The witness may be served with a subpoena, compelling him or her to attend the deposition. The term subpoena is usually a shortened version of the Latin term subpoena ad testificandum, which is an order to testify under threat of legal penalty. A subpoena ducis tecum is served if the witness is required to bring certain documents to the deposition. Attorneys may choose to send the witness a list of questions in advance of the deposition. Examination in such cases is referred to a deposition on written questions. The witness may be formally requested to attend by service of a subpoena along with the list of written questions. Then you have production of documents and things. Lawyers for either party may serve the other side a formal request for permission to examine documents and other materials related to the case. State or federal rules allow the party to whom the request is made a certain number of days to reply. The response can be in form of granting formal permission or filing an objection to examine the documents or other materials listed in the request. If an objection is filed, the attorney submitting the request may file a motion to compel discovery, asking the court to rule on whether examination of the materials should be allowed. The court must then settle the matter by either granting or denying the motion. Permission to enter on land. Attorneys for either side formally request permission to enter land or other property owned or controlled by one of the litigants in the case. Permission may be requested for purposes of inspecting, measuring, surveying, photographing, testing, or sampling the property in question. The litigant receiving the request is required to respond in the manner described for production of documents and things. Then you have physical and mental examinations. In cases involving disputes over the mental or physical condition of one of the litigants, The court may order the party in question to submit to a physical or mental examination. The order may be made only after the motion for good cause has been filed by the attorney requesting the examination. The party to be examined must also be given notice of the upcoming examination. Then you have requests for admissions. Attorneys for either side may serve the opposing side a written request for admission of the truth of any matter relating to the case. A request for admission may concern statements, opinions of fact or law, or the genuineness of certain documents. The party receiving the request must file a written answer within a number of days established by federal or statute rules. The answer may take several forms, including the following: denial of the matter at issue, one of more reasons why the matter can't be truthfully admitted or denied, an objection to request filed together with reasons for the objection. Certain steps may also be taken to preserve physical evidence or safeguard people involved in an action. The court may, for example, be persuaded to issue a preliminary injunction, temporarily forbidding certain actions that may adversely affect the collection of evidence. The court may also issue a temporary restraining order, forbidding certain activities or contact between parties in order to prevent irreparable harm or loss to the party seeking the injunction.